who is professor at the Hebrew University and visiting this year as a professor at Columbia. He is one of the leading, I can praise you, leading international law scholars in Israel, certainly of the younger generation, and he's coming on strong. He's an expert in international tribunals and is head of the Minerva Center for Human Rights, which is the leading academic institution that investigates and promotes human rights issues in Israel and around the world. And he's going to speak today on the legal status of Jerusalem. Some of the students asked if anything was off limits. I took the liberty of saying no. Again, thanks to Yuval Shani.
Thanks, Marshall, for having me. Thank you for coming. I look forward to sharing some thoughts with you, listening to your questions, and addressing them to the best of my ability. So let me start by offering a couple of preliminary observations on the topic and its relevance. I'm going to, as Marshall asked me and suggested that I would address the specifics of the legal status of Jerusalem, so I'm going to survey some specific legal arguments that have been raised in the past, both by Israel and Palestine, and offer some of my own critical assessments of these arguments. But before that, in a way, this discussion, which we will engage on the legal status of Jerusalem, first cannot be detached from the broader Israeli-Palestinian conflict. So it's in a way, I'm going to emphasize on issues related to Jerusalem, but many of the issues and many of the legal claims are much broader in their scope and in their implications. So at times it will be difficult to have an independent Jerusalem focus. So this is about the scope of coverage of the presentation itself. The second is more, let's say, a reflective thought about the role of law in resolving conflicts, such as the conflict of Jerusalem. And what I think we should be perhaps discussing during the Q&A is whether law here is part of the solution or part of the problem. One of the interesting aspects of the legal status of Jerusalem discourse is to see how little of a role the law did actually play in shaping policies, not only by the immediate parties to the dispute, but also with regard to third parties. And I think this says something more broadly about the promise and limits of laws in general and international law specifically. So there may be areas where applying the somewhat crude or binary outcomes that laws often provides, especially in questions of sovereignty, this either belongs to A or belongs to B, this is too limiting. And if we will have time, we can discuss some future settlements that could be accepted. My best guess would be that the final solution for the Jerusalem issue would not be a dichotomous settlement where one party gets everything, the other gets nothing, or even right in the middle split. So these are my two preliminary introductory statements. So I'm going to start with the Israeli, some of the theories that have been forwarded by Israel concerning its legal claims over Jerusalem, but more broadly over other parts of mandatory Palestine. I'm going to criticize some of these claims as we go along, and then I'm going to shortly also discuss the Palestinian counterclaim, and we'll reach some tentative concluding observations. So from an Israeli point of view, the legal case and we're talking here, we're not talking about the history of the Jewish people, we're talking about the legal case from Palestine. The critical date that one should remember when reviewing the Israeli case is the 1922 League of Nations mandate, which is an extremely important instrument, which is often being somehow, even within Israel, quite surprisingly, it is being glossed over. Students in the Israeli education system learn about the Balfour Declaration, the 1917 political platform that was espoused by the British government, and they learn about the Partition Resolution in 1947, where the UN has recognized the right to a Jewish state in parts of Palestine. But the mandate is actually the more important, and from a legal point of view, the strongest instrument that the Zionist movement has been able to procure. The situation after World War I is that areas, well, there are these empires that have disintegrated, in our case the Ottoman Empire, and their territories have been basically taken over by the victorious powers of World War I, and the mandate system, which is introduced after World War I, is a political arrangement which is transitional in nature. So it's, in a way, it's a rejection of the old colonial policies, which simply conferred on the Western powers the sovereignty de facto of some areas, of some territories in what we now call the developing world. The mandate system was a much more, in a way, progressive notion, which did not confer sovereignty over the territory with the mandatory power, but rather allocated a sort of an international trusteeship, or a sort of guidance role for the mandatory power that would eventually enable the local population in the mandated territory to attain self-governance. So the ideology, the Wilsonian ideology, which underlied the mandate project, was that eventually the sovereignty lies with the local population of that territory, and the mandate system was transitional in nature, and this is indeed how it worked out. In the different mandate territories, it was a transition, sometimes a very long transition. So the Namibian case was one of an extremely long transition, but eventually this is how it worked out. And this is what happens in 1922 with regard to Palestine. Palestine is being designated as a Mandate A territory, namely there was a division into three categories. The Mandate A territories were the closest to self-governance. The population in the Mandate territories was perceived to be as close, to be the closest among these groups of states to self-governance. Hence, the transition was expected to be relatively short. And the mandate provided Great Britain with the legal authority to administer Palestine. Originally in 22, the Palestine was, of course, the west bank of the River Jordan, but also the east bank of the River Jordan. So it was a vast portion of territory. In 1923, the British have attained the permission of the League of Nations to alter the terms of the mandate and to exclude the east bank of the River Jordan, Transjordania, what now is the Kingdom of Jordan, from the scope of the mandate, and an independent Arab state is being created in that area. Now, what's unique about the 1922 mandate is that, unlike other mandates, where you can regard the mandate, as I suggested, as ultimately a disposition, a commitment to dispose a territory in the future to a certain, a commitment to dispose a territory in favor of the local population that would ultimately establish their own political institutions, probably statehood in that area. This attribute also, we can find it in the 1922 mandate, but what's unique about the mandate is the dissonance between the composition of the population of Palestine in 1922 and the beneficiaries of the mandate. So normally the assumption is that the mandate is designed to guide, to assist the local population in reaching independence. What's different about Palestine is that at the time when the mandate was approved, 10% of the population was Jewish. 90% of the population was not Jewish. And but still, the mandate speaks expressly about realizing through the mandate the Balfour Declaration of 1917, which called for the establishment of a Jewish national home in Palestine, and it designates the Jewish Agency, the executive arm of the Zionist movement, as the agency that would assist the British mandatory in governing the territory, aka the transitional local partner. So what is here, and this is of course part of the problem. Part of the problem is that the mandate was exceptional. It did not comply with the principle of self-determination in a mechanical way. So it was not the expression of a self-determination of the local population. Instead, it was a commitment to dispose the territory in favor of a state in the making project that was initiated by a minority of the population. Now, is this permissible? Could the mandate have actually conferred a legal title upon the Jews in Palestine? The Arabs, the Arab countries, and the Palestinians have argued vigorously that by changing, by creating this exceptional form of mandate, which deviates from other mandates, the mandate of 22 had been flawed and runs contrary to Article 22 of the League of Nations, which prioritizes the wishes of the local population in the designation of the mandatory power, but also in the structuring of the mandate itself. So there is an argument here that there has been something which is inherently problematic with the 22 mandate, and as a result, the argument is it could not have conferred a valid title upon the Jews, upon the Zionist project, upon the Jewish Agency, or eventually upon the State of Israel. Now, what does Israel have to say about these alleged defects with the mandate, alleged problems? I think the main argument that is being raised in Israel, or I should say, well, returning to my preliminary observation, these things are not being debated very vigorously in Israel. So most of the positions I'm actually presenting as the Israeli positions are positions which have been raised by Israelis over the years. I'm not sure that the government of Israel is even aware of these arguments, since this is not regarded as a very live issue, the validity of the 1922 mandate. So Israelis over the years, or pro-Israeli scholars over the years, have made the following observations, which I basically subscribe to. First, the argument is that self-determination in 1922 was a very open-ended concept. It was a concept which has just been introduced. It was not a legal right at the time. This is only a post-UN Charter development. It's a political concept, and it actually, at times, has been implemented not through strict observation of existing demographics. So, for instance, in the Balkans, after World War, before World War I and after World War I, the notion of transfer of territory has been regarded as part of the concept of self-determination and the building of nation-states. And in the specific context of Palestine, the anticipation was that by declaring Palestine as a Jewish state, Jews would emigrate en masse to Palestine and would change, as indeed had occurred over the years, and would indeed change the demographic composition of Palestine. So eventually there would be compatibility with the mandate and with the Zionist project, with the wishes of the large majority of the population in Palestine. And the numbers which Churchill is citing in those years around the conclusion of the mandate is 3 to 4 million Jews that he expects would shortly emigrate to Palestine. At the time, we had something like the whole population of Palestine was 750,000 individuals altogether. So the idea was that this is just a transitional arrangement. At the end of the day, the population would stabilize in a way which would comport with the principle of self-determination. Second, before the League of Nations, the League of Nations had reasons to believe at the time that the Arabs, or at least the Arab elites, and again, to use the word Palestinians is in a way, at this era, maybe premature, because there was not before the mandate, there was not a strong sense that there is even a Palestinian people. This is developed subsequently in time. There were some representations made by prominent Arab leaders, most notably the Emir Faisal, who was part of the Saudi royal family and had the title, he was one of the claimants for titleship over parts of the Near East. There was this agreement that he formed with the Zionist leadership, with the Weizmann-Faisal agreement, where he presented no objections to the actual immigration of Jews in Palestine and the creation of a Jewish political entity there. So there was at least a sense that the Arab population, this is of course historically we know is a gross misrepresentation, but when the mandate was actually accepted, there has been a generally wide perception among the dominant powers that the local population, the local Palestinian or Arab population, is not at least strongly opposed to the project of the establishment of a Jewish national home in Palestine. And the thinking was Jews would come, they would bring investments, they would bring economic developments, and from an area which is now backwards area of the world, this would actually bring prosperity for everyone. So you could say that at least from the decision makers' perspective, they did even comply. They thought they were complying with the requirement to consult or to prioritize even the wishes of the local population. And the third line of argument, and this is the argument that James Crawford is making in his book on the creation of new states, at the end of the day, it doesn't matter. It doesn't matter because once the League of Nations issued the mandate, there is no system of constitutional review where you can actually challenge the legality of it. It was an act of disposition. It conferred international legitimacy upon a sovereignty claim, and even if the process has been somewhat defective, that does not change the nature of the act of disposition. So the Israeli case would be that the mandate would serve as a strong foundation for the initial sovereignty claim of Israel over Palestine, that the defects in the mandate are mostly are either marginal or high historical in the sense that they're being analyzed with the laws that we have now and not with the laws in accordance with the laws that existed in the time, and that in any event there has been a disposition. Okay, so this is chapter 1, and this does not deal only with Jerusalem. It deals with the entire question of the territory, of the status of Palestine. But as we know, as a political project, the mandate has been a failure, or has been, or let's put it in a more careful manner, it has not progressed smoothly, the process of transformation from mandatory governance to the building of a Jewish national home. And rather soon in the game, it became apparent that the Arab population in Palestine is literally up in arms against the creation of a Jewish state in Palestine and against Jewish immigration to Palestine, which was part of the justification of the process that you are going to affect major demographic changes. And the British, they tried to negotiate some sort of settlement, which essentially reflected a withdrawal from the original mandate towards some sort of partition of the territory. This did not work very well as well, so at the end of the day, the Brits decided that they don't want anything to do with Palestine, and they returned the mandate to the General Assembly, and the General Assembly decides on 29 November 1947 on the partition of Palestine, of mandatory Palestine, into 3 territorial entities, and here the Jerusalem issue starts becoming unique and interesting. So there will be a Jewish state over just over 50% of the territory. There would be an Arab state over most of the remainder of the territory. And with regard to Jerusalem, there will be a separate arrangement called Corpus Separatum. So Jerusalem, defined rather broadly in terms of geographical terms, would be subject to a temporary international custody administration. The UN will run Jerusalem for a period of 10 years. This, at the end of the period of 10 years, the UN Trusteeship Council would decide what to do with Jerusalem, inter alia, on the basis of a referendum that would take place among the inhabitants of Jerusalem, and then the decision would be taken whether to continue international administration or whether to annex Jerusalem to one of the existing states, or maybe find some other solution. So the 47 UN resolution has, in a way, altered in terms of the solution that it offers. It substantively alters the terms of the mandate. And of course, from a Jerusalem perspective, it moves away Jerusalem from the title that was given to the Jewish project, or to the Jewish National Home Project in 22, and allocates it to an international administration. So the legal question here is, what is the status of this resolution? Does it actually effectuate a change? Does it change the title that was disposed in the mandate, or at least the commitment to future disposition in the mandate? And this question, of course, is extremely controversial. The Israeli writer's position has been traditionally that whereas the 47 resolutions confers political legitimacy upon the creation of a Jewish state in Palestine, it does not, generally speaking, change the value. It does not annul the 1922 mandate. Why is that so? First, although the resolution has been adopted by the General Assembly, which is not a decision, it does not have the power to issue binding decisions. Although you could make, this is, I should say, somewhat a dubious argument, because you could say that the Assembly did step into the shoes of the League of Nations as the sort of default sovereign over these internationally administered territories, and could exercise these powers of disposition. But the more convincing argument is that the language of the resolution itself is a recommendatory nature, namely that the resolution uses the words recommends the following solution. So even if you could make the argument that the General Assembly can issue binding decisions in these matters, this does not seem to have been the mode in which the General Assembly had operated in this context. And indeed, it has been rejected by the parties. Well, the Our Party had rejected this, and as a result, you cannot make an argument that this has been validated by way of agreement of the parties. There was clearly no agreement. And in a way, even the half-hearted attempts after 47 and 48 to return to the partition plan are indicative that the international community at the time did not view this document as a legally binding instrument. It was perceived as perhaps a politically expedient program, which is something very different from a legally binding instrument. And over the years, one could argue that it has fell into desuetude and no longer has legal force. So, In 48, when Israel is being established, it can make, I think, a plausible claim that its establishment is supported by the mandate of 1922, and is generally in line with the, at least at some level, with the partition resolution, which called for the creation of a Jewish state. And here things, again, we have this additional layer of complication, which again reflects upon the status of Jerusalem directly. So Israel is being established, a war erupts, the 48-49 war, and at the end of the war, Israel occupies West Jerusalem. Namely, it goes beyond the borders that were allocated to it by the 47 decision, but of course it is still within the framework of the 1922 mandate. On the other hand, Jordanians are Jordan has been able to occupy the West Bank and East Jerusalem, and Jordan then moves in Israel moves to exercise its jurisdiction, namely to annex West Jerusalem, and Jordan in 1950 moves to annex East Jerusalem and the West Bank, following some dubious, I should say, process of consultation with village elders throughout the West Bank, and this has been adopted by the Jordanian parliament in 1950, this act of annexation. Just a word on the Jordanian act of annexation. There is generally broad, at least at the time, there was generally broad agreement that the act of annexation by Jordan is unlawful, namely that Jordan has been an occupying power in the West Bank and in East Jerusalem. Very few countries in the world expressed support for this act of annexation, and in fact the Arab League at some point in time threatened to throw away Jordan from the League on the basis of that act of annexation. So it was facing expulsion from the Arab League, and they had to issue a clarifying statement which basically contained a no prejudice provision. So they basically stated that everything they have done in 1950 is without prejudice to the final settlement of the Palestine issue, and eventually down the road in 1988, Jordan gives up any claims that it may have had with regard to the West Bank and East Jerusalem, and delegates any right that it may have had to the Palestinians. So Jordan is actually leaving the picture at some point in time, and its presence within the picture is, as I noted, quite controversial. Just another element which is still relevant to these years, 48-49, you have a ceasefire agreement between Israel and Jordan in 49, and that ceasefire agreement demarcates what is now called the Green Line, the border which between Israel and the West Bank, which cuts through Jerusalem. Both parties provide in the 49 agreement that the demarcation is executed solely for military purposes and has no prejudice upon the final borders of Israel or Palestine. So everything that happens around these years, again, if you take the view that the mandate is still in force, everything that happens in 48-49 does not affect the validity of the mandate. However, if the mandate is not in force, then I will return to this momentarily. Some legal implications can ensue from this chain of events. Moving very quickly, because I see my time is running out. 67, Israel conquers the West Bank and East Jerusalem, and then moves to annex East Jerusalem. The annexation is not called initially an act of annexation. It is called the extension of Israeli law, administration, and jurisdiction to East Jerusalem. Again, this is, in this respect, Jerusalem is unique. The West Bank is not being similarly brought under the scope of Israeli laws, administration, and jurisdiction, but Israel applies this to East Jerusalem. But in 1980, the Knesset, the Israeli parliament, adopts a basic law which proclaims that Jerusalem, United Jerusalem, is the capital of the state of Israel. And here it's hard, from this point onwards, it is hard to maintain with a straight face that the 67 Act was not, in effect, an act of annexation. So basically, this is the narrative. What we have in the 1990s are the agreements, the Oslo Accords with the Palestinians, which the relevance to our discussion is merely that Israel and the PLO have agreed to conduct negotiations on a number of final status issues, one of which is Jerusalem. So you could say that Israel has agreed to negotiate sovereignty over Jerusalem, but it did not renounce, of course, any of its claims. So what is the Israeli claim under the two theories, which are the two dominant theories which are out there? One is the mandate-based theory, which argues the mandate has never been officially revoked, or alternatively, the mandate was a one-time disposition of title, and that title was transferred in 1922 to the Zionist movement in order to create down the road a Jewish state, and by virtue of that legal entitlement, Israel has the right to exercise sovereignty at whichever parts it wishes that fall within mandatory Palestine. So if you take seriously the mandatory authorization theory, Israel could annex tomorrow other parts of the West Bank and would be operating within its right. The second theory has been developed in a way as an alternative to the first theory, because there have been the chain of events around 47 and 48, namely the return of the mandate to the UN, and in a way the new position taken by the UN in the partition resolution over the nature of the division of the land. This has put doubt over the validity of the mandate theory, and the question is whether you can come up with some sort of justification which is other than the mandate. And here comes into the discussion one of my colleagues from Hebrew University, Yehuda Blum, who was also an ambassador, the permanent representative of Israel to the United Nations, and he introduced the missing reversionary theory, which basically posits the following. In 48, indeed, there was the status of the territory has been rendered uncertain. So the mandate had concluded. The act of disposition, in a way, was cut in the middle. The process didn't come to fruition. So what we have is a sovereignty vacuum. You have a sovereignty vacuum, which he says is analogous to terra nullius type of situations, where you have these desolate islands, which no one has discovered, and the question is who gets valid sovereignty over such a terra nullius, such sovereignless territory. And according to Yehuda Blum, the first state that takes legally effective possession over the territory and claims sovereignty over it would fill that vacuum in a way which is analogous to the way international law regulated the acquisition of title over new discovered islands and territories. So it's quite an ingenious argument. And according to Yehuda Blum, in 48, Israel, who had at least some international recognition by virtue of the mandate and the partition resolution, it exercised effective jurisdiction over part of these territories. As we've seen in 48, 49, it had attained control over what we call now the Green Line, which is more than 70% of mandatory Palestine. And what's important to Bloom's theory, this has been done through legal means, namely the use of force in a defensive campaign. In Yudas Bloom's argument, this is a very critical link in the chain. So Israel was established on 14 May 1948. The following day, it is being attacked by neighboring Arab states, and it is pushing them back and acquiring territory in the process. So according to this form of argument, the acquisition of title has been lawful, and it was followed subsequently with the sovereignty claim with regard to East Jerusalem. And what about the Jordanians? Because it should apply both ways. If the Jordanians fill the vacuum, they could also be entitled to make a sovereignty claim to annex the territory. So in a way, Bloom's theory could have been a double-edged sword, because it could also justify the 1950 Jordanian annexation. But here Bloom says, no. The Jordanians have acquired the territory through an act of aggression. They have invaded Palestine. And as a result, they are now, their title has been invalid. And when Israel reoccupied in 1967, again, in a defensive campaign, this was the first time that the vacuum was validly filled out. So, what about these theories? First, these theories are difficult because they are based on an interpretation of very complicated fact patterns on the basis of quite innovative and imaginative theories. So I think it is fair to say that the theories have been controversial. The Bloom approach specifically seems not only you can argue about the facts, who was the aggressor, who was the victim, and whether Jordan in 1967 was the aggressor or the victim, or whether in 1948 the Arabs were not exercising a right to humanitarian intervention, as they have argued. So the facts of who was right and who was wrong are very controversial. But even so, I would say that it's difficult. Let's put it differently. When you think about what is the role of law in this regard, why do we reach out and explore and analyze these complicated conflicts from a legal perspective? I think that the answer would be, at least at some level, that the law confers some international legitimacy and respectability to some of your political claims in this regard. And when you view it from an outcome-based perspective, Israel has not succeeded through the application of these theories in generating any significant legitimacy to its claims with regard to East Jerusalem, especially the other part of the story. And even with regard to West Jerusalem, I should say, the jury is still out, or more specifically, the embassies are still out. And the reason why it is still out, because the international community has not fully bought even the more minimalist theories governing the 49 lines, and has not fully accepted the demise of the corpus separatum idea, which adopted by the UN in 47. So in a way, these theories, interesting as they may be, their interface with mainstream international law, and certainly with mainstream international politics, has been quite limited. And when you have a theory which is controversial on questions of sovereignty, ultimately the decisive factor is going to be on this matter counting heads. You will see, so if we're talking about Kosovo, for instance, is Kosovo a state or not, a key element in the equation would be the head counting. How many states have accepted the theory? How many states have rejected the theory? So on Kosovo, you could really say the jury is out. You have 50, 60 declarations of recognition. Here, with regard to Israel's claim over East Jerusalem, the numbers are extremely small. I think maybe one or two. I don't know, maybe Micronesia has also accepted this. But the U.S. administration has not accepted these set of positions as a practical matter of policy. Maybe we can discuss this later. Okay, so these are the Israeli theories. Their ability, their degree of acceptance has been quite limited. What about the Palestinians? So the Palestinians, we've seen some of their, in a way, negative assertions, why the mandate has been defective, why maybe the resolution in 47 should be regarded as a binding statement because the UN can decide, can adopt binding resolutions. I think the heart, of course, of the Palestinian claim over the West Bank and East Jerusalem has to do with the principle of self-determination, which I already mentioned. There is very, I think, strong support to the proposition that after World War II, self-determination is becoming a principle of international law, a very important principle of international law. And while this principle is limited by notions of territorial integrity of existing states, situations such as the Palestinians find themselves in the West Bank and Gaza Strip and East Jerusalem in this regard, namely that they are situated, this people is situated in an area over which no state exercises internationally recognized sovereignty. So this would be, in a way, the classic set of circumstances for the realization of the right to self-determination. Israel does not contest that Palestinians have a right to self-determination, and they have accepted that that right should be realized. Even Netanyahu has finally accepted the two-state solution as the only game in town, at least from at present. The question which remains is, and here I think is the weakness in the Palestinian case, is what does the right to self-determination, what does it say about borders? There seems to be a very easy, and in my view, not always very sophisticated equation between having a right to self-determination of a people and the territorial integrity of that area. So when, for instance, for the International Court of Justice, in the Wall opinion, one of the problems with the construction of the wall is that it undermines Palestinian right to self-determination because it annexes, according to the ICJ, 16% of the West Bank. However, you can think of a scenario where a people has a right to self-determination, yet other states have valid sovereign claims over part of the territory which is now being populated by this people. And when one is dealing with East Jerusalem, the question is ultimately, are Israel's claims over East Jerusalem, which are based on the mandate, and maybe also on some degree of effective control that the State of Israel had for a very short time over parts of East Jerusalem, are these claims necessarily inferior to a Palestinian self-determination-based claim? You can put it even in a more demagogic way. Should we give effect to the ethnic cleansing that was executed by the Jordanians in 48 and 49, where they rendered the West Bank and East Jerusalem as free of Jews? But I should admit that this is I said it's a demagogic argument because it, of course, cuts both ways. I mean, both parties were engaged in ethnic cleansing in 48, 49, and Israel had rendered West Jerusalem largely devoid of Arabs. So I would not advise the Israeli government to, in a way, open this Pandora box. And I think that if we were to adopt an international law-based determination of the status of Jerusalem, the international with the support of the international community, the settlement would revolve around the 67 lines, the 49 lines, which have attained over the years, although they were not created as an international border, they attained a lot of the legitimacy and the stability which normally is appertained to international borders. So the same kind of extension, for instance, that we have seen in the Yugoslavia case, where when a state is dissolved, and the question is where would be the new borders between the old federal units, so you hang on to what you've got. So if you have a federal system and you have federations with more or less ascertainable borders, you seize to that. So the uti possidetis rule, which is a rule of international law, which deals with the stability of existing colonial borders, has been expanded with the Yugoslav case also to internal federal borders, and I think it will be also applied in the Israeli-Palestinian context with regard to the 49 lines, because at the end of the day, there are international concerns about stability and ease of application, which compensate for some of the specific injustices that are associated with opening up these Pandora boxes of past wars and past injustices and past crimes. But returning to the beginning of my presentation, I don't think that this is going to be the final outcome. I think this is going to be, in a way, the point of departure for agreeing upon the final outcome, but I don't think that the final outcome in Jerusalem would look like the 49 line in terms of its of the actual division, and certainly not in terms of the regime that is going to apply there. Why not? Because the international law will apply, is not likely to apply in circumstances where one party, in this case Israel, perceives itself to be relatively powerful militarily, and also in some respects diplomatically, in the sense that it can count on the support of some key states to derail any attempts to enforce a settlement upon it. And we are likely to see, therefore, a negotiated solution that is not ignorant of the default rule that international law would present, but is not going to adequately reflect it. And my guess would be that what we will be seeing would be some degree of division, which would, in terms of how this would be actually applied, would probably involve some creative redefinitions of what Jerusalem is. So we will probably end up not with division of Jerusalem, but with the emergence of two Jerusalems. There will be a Jewish Jerusalem, which will have borders that will coincide with the major Jewish concentrations of population in Jerusalem. And then there will be a broader Palestinian Jerusalem, which would start in Abu Dis, an area which is currently not part of Jerusalem, but could be regarded at some level as part of Jerusalem. It was certainly within the Corpus Separatum, and would expand to cover many of the Arab neighborhoods that are currently within Jerusalem. And then we will have a special regime, my guess would be, with regard to the Old City, with regard to the holy places, where you may end up re-adapting the Corpus Separatum notion at some level, some degree of international administration, maybe religious administration, that would, in a way, not split the pie in the middle, but create some modus vivendi which the two parties can swallow. The question, in order to operationalize this, and this is, I think, currently the key issue, after we resolve the politics of the matter, is whether you can find some reasonable security arrangements that could enable residents from both sides of the city to reach the holy places. And this is actually a critical issue in such a bargain. So at the end of the day, and here I conclude, we can analyze what is the legal status of Jerusalem. It is not irrelevant. I think this is an interesting case where you can see the limits of the legal discourse, even if you have good legal claims. If they're not adopted by powerful entities within the international community, there's very little mileage that you can actually use them for. So this is one lesson. The other lesson is that law does not automatically translate into reality where you have sufficiently high stake interest and a certain balance of powers, which rejects the formal and more crude legal application. And finally, you have here an interesting dissonance between law and facts, law and reality. So when the legal prescription, let's say the mandate theory, is so out of touch with subsequent developments on the ground, the law loses its credibility and is unable to translate itself to operational settlements. So these are some of the limits of the legal discourse. So law is not completely irrelevant, but I wouldn't look at the law as the major source of resolving this conflict of Jerusalem. So I would be very interested to hear your thoughts, comments, questions, etc.
We have about 15 minutes for questions, so please focus on questions, not comments. If people want to take some refreshments, they can do it now. And when we continue this outside, if people have questions after we've been thrown out of this room,
Yeah.
it's open. The floor is open.
Sure.
It's a question, it's not a comment, popular question.
Yeah.
I've always been intrigued, and I've never wanted to ground, like you think about the ambiguity of who has control under the 1945 U.S. Charter over the disposition of trusteeship. It says the GA does if it's non-strategic, and the council does if it is.
Right.
It's not clear how you say it's strategic. But if, in fact, the GA did conclude that Halifax statute was non-strategic, then it would give them the confidence, at least, to dispose of the petition file on the jails, for example, not adopting it.
Yeah.
And secondly, because when I look at encyclopedias in the U.S. Charter and writings, there's very little detailed practical analysis. So the fact that nowadays we like to have an accurate under chapter 7 and after 35
Right.
doesn't mean it was true for 5. And so to the fact that you're now giving me that total activity of the charter, although that the council are inclined to say that GA resolutions are lacking in only. Even a GA resolution is only recommended. I think in the context of the time, Pache Chalmania, one recommends might be a stronger one than the silence of the ordinary resolution.
So in a way, your second question answered my first question. So the act of I didn't argue that the General Assembly could have disposed of the territory. Technically speaking, this was in a way an unprecedented event in the sense that the mandatory power has returned the mandate to the substitute authorizing body and requested for assistance in the disposition. So I would be open to the thought that the General Assembly could dispose of the territory if it's so chosen, if the Security Council had not voiced its opposition to that act. So this could be a valid act of disposition. I would still, however, argue that the use of the term recommendation in the preamble to the resolution does mean that that in the context of this specific resolution, this was not intended to be a legal act of disposition, but rather a recommendation of a political platform.
Do you agree that methodologically, when we have to analyze
Yeah, sure.
the time, it's recommended?
I agree. I also noted that in terms of the follow-up reaction, the fact that it was that the Arab states felt free to reject the recommendation at the time without facing any political or legal consequences, and that the UN itself was not, too interested in pursuing this matter down the road. These are other indications of the less than binding status of the resolution. Yeah.
I'm curious, and the other huge dimension of the legal aspects of it, which you covered beautifully, but that other dimension has to do with the historical nature of the area that we're talking about. And maybe you can answer the question for me, why isn't the history of the area brought into focus fundamental emotions or whatever, there's people that's been like exalted, there's a life, but that, you might, I don't know, that's a dimension for me that I don't know why some of the school shouldn't be.
I mean, that's a great question. I mean, the short answer that there is no, you cannot acquire a sovereign title under international law merely by virtue of having historical rights to a territory. The fact that you have some historical affiliation to a territory is not in itself a reason to acquire sovereign rights. It could, of course, I mean, it's an incredibly important part of the political process that eventually leads to the conferring of sovereignty titles. So the 1917 Balfour Resolution was very acutely aware of the historical ties of Jews to Palestine, as was the mandate. So it's in the background, but you cannot derive rights from history unless that history in specific context implies effective control. So for instance, for these island issues, then the facts on the ground would be maybe dispositive of the sovereign title. But the framework where we are dealing with, where you have a chain of sovereignty, so you have an Ottoman Empire that has internationally recognized sovereignty, and then this sovereignty is moved on through intermediate. The fact that you have historical claims simply doesn't find a room in the process, and I agree that this is another illustration of the limit of the legal discourse. It is, in a way, high historical. Yeah, I fully subscribe to this.
Can I ask a question about the reversionist theory?
Yeah.
Presumably, Jordan's entry into the West Bank and East Jerusalem is illegitimate because it's an quote aggression, and therefore it's not recognized.
Right.
Now, Israel is self-defense, but how would you deal with the issue of Israel entering into Jerusalem, which was supposed to be part of the Corpus Separatum?
Well, look, if the Corpus Separatum plan has been dead, then this is not...
But if it's dead, then why... Let me put it this way. If it's dead, then... And if the whole partition plan is dead, and if the entire area is terra nullius, then the entry of Jordan in 48 would be as equal to the entry of Israel in 67. Because it'd be two people without any normative claim making a claim of physical taking. And one physical taking you make, and either that gives you normative title, or if it doesn't give you legal title, then the next guy's physical taking, you may give him the right of occupation, but it wouldn't. Why would it give him normative title? What I'm trying to say is, if the Jordanians don't get normative title, why do the Israelis get normative title? I could see saying that Jordan had no greater right than Israel, and Israel has possession.
Yeah.
That would be reasonable. Like, no one has normative title. Jordan took it. They have rights of possession. Then Israel took it. They have rights of possession. But it's the normative title part that I don't.
Well, first, I'm having a difficulty defending a theory I don't believe in, but I'm willing to do it.
I'll tell you who the Bloom that you
yeah, I mean, the answer that Bloom would give you is that while you can view view the area as a vacuum, you still had to justify your presence in the area. And Israel justified its presence in the area because there was some international legitimacy at this point in time for a Jewish state, as reflected in the mandate.
But not for Jerusalem.
But still, I mean, there was, when you're talking about who can actually assert jurisdiction or assert title in Palestine, it's not the whole world. So if the U.S. would have sent troops there, it probably wouldn't have done the trick. The question is whether you can actually establish an internationally accepted presence within Palestine. And there, according to Bloom, there will be only two candidates, the Jews and the Palestinians. So if the Palestinians would have formed a state in 48 and occupy East Jerusalem, he would have to, well, he probably would have had to invent a new theory, but he would have to accept that this would be a valid exercise of international authority. The Jordanians had no business being there. So
then
there.
my last question is, this is good against the Jordanians,
Yeah.
because in 1967 there was no Palestinian polity.
Mm-hmm.
Now you come to 1980, there's a Palestinian polity. Why is the missing reversion of good against the Palestinians who now
Because
have
East Jerusalem has already been taken by Israel through in Bloom's view, in according with a valid claim of sovereignty. The Palestinians now, if they were to establish a state tomorrow in the West Bank and claim sovereignty over the territories they control, then according to Bloom, they're entitled to do so. There should be a problem.
We'll take one more question and then we'll shift into informal outside.
Shifting to 2009 and looking at the basis, well, no, I have to go to 2009, of course we do that. If you're looking at international law and basis, now coming into place in the paradigm, and talking about violence and conflict, and looking at the Board of Inquiry, how do you fit that in along with the ICC and other regulations, and looking at what the IDF is doing, looking at Hamas, looking at all the parties who are escalating violence and actually committing what would be argued as humanitarian crimes from all parties, like killing them, moving forward with that concept. So I'm just curious, how is the humanitarian law now that it's much more involved than it was earlier?
Yeah, it's a difficult question. I mean, first I should have mentioned that before that when dealing with Bloom theory, one of the objections to the theory that it runs contrary to the prohibition against annexation of territory under IHL. So IHL is also part of the picture, not a big part of the sovereignty picture, but it is a part of the picture. I think that the general observations I made about the limited role of international law are in a way beginning get eroded when one is dealing with IHL in view of the strengthening of some international enforcement mechanisms, which raises the stakes for a country like Israel, not necessarily for the other parties to the country, but it renders a country like Israel more vulnerable to international pressure in fora over which it doesn't exercise, even by proxy, a high degree of control and influence. So if you are going to encounter ICC proceedings or universal jurisdiction cases in Spain, Belgium, what have you, then you have to reassess your position towards the political impact of legal rules. And I think in a way Israel is now, it is now learning a lesson in this regard. And the recent event in Gaza did, well, before my discussion was about the limits of law, I think in Gaza we have learned a lesson of the limits of power. There is only that degree of tolerance by the part of on the part of significant parts of the international community to what is being perceived as deviation, right or wrong, as deviation from acceptable norms of behavior. So in this respect, I think the law of IHL and international criminal law, with its more aggressive enforcement mechanisms, is changing the role of law in the calculus. This has not happened so far with regard to the sovereignty case, although I should say that it is always in the background, and my belief on this is that the reason why Israel is singled out in many of these fora and is being subject to a tighter scrutiny than other states are subject is because there is a general sense that the Israeli case is fundamentally unjust, that Israel is depriving a people of its right to self-determination. So although, of course, we know that there is a sharp distinction between jus ad bellum and jus in bello, in theory, in the way these mechanisms are actually being operationalized, the sovereignty case is lurking in the background and is affecting also. So you could say that through the back door, these mechanisms are also raising again the sovereignty. Just today, if it's not related really, but today there was a decision by the European Court of Justice which held that Israel cannot trade with the EU, that products, that have been manufactured in the occupied territories cannot enjoy the free trade benefits that Israeli products have with the EU. So the sovereignty case has spillover effects to other areas of international relationship where you have stronger mechanisms, and this in the long run, you could say also affects the calculus on the sovereignty.
We are going to have to vacate this room. I want to thank very much Yuval Shani for an extraordinary tour de raison and very exciting.